and gentlemen, we're about ready to reconvene. I want to make a quick announcement. Due to some needs by board members and staff, we will continue this till 7:30 tonight. That's the latest date, and if we have to, we'll reconvene tomorrow. Madam Clerk?
Item 39 is from the Planning Department. Conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-717 for James Hansen on APN 046-017-098, file 2016-717.
Thank you, Madam Clerk. Okay, ladies and gentlemen, our procedure will be, this will be a hearing. Staff presentation and board questions of staff will occur first. Presentation by the appellant or representative and/or. Presentation by member of the public shall be limited to 5 minutes per person. That'll be the public comment period. Summation and rebuttal by appellants will be 15 minutes allowed for that, a maximum of 15 minutes. Staff summation and rebuttal. Sir, rebuttal by members of the public. That'll be another second public comment, if you will, the rebuttal. We'll have board questions, then we'll close the appeal hearing, and then board discussion deliberation. Having said that, Mr. Maurer?
Thank you. Miguel Contreras will present this item.
So this is Miguel Contreras with the Planning Department. I'm here to present the mentioned item.
Miguel, I'm going to ask you to speak real loud.
How's this? Better?
Excellent.
All right.
Good.
This is an appeal for a Planning Commission denial of an appeal of a Planning Director's denial. This is for James Hansen, application 2016-717. The subject parcel is located on the north side of Highway 12 across from 622 Highway 12 Valley Springs. And essentially what happened was upon review of the application for commercial cannabis registration, it was noted by planning staff that the appellant never submitted a NOI to the water board, which is a September 7th requirement. He was denied for this reason. At the Planning Commission hearing, or with his appeal for the Planning Commission, the appellant submitted a date stamp photo that showed that he filled out an NOI. The photo also showed a checked address to the Central Valley Regional Water Quality Control Board for the amount of $2,500. And he also submitted a second photo showing an envelope with the regional, for the water board's address at their Reading office. However, the water board never received the NOI. They did not receive payment or of any sort. The appellant claims that he mailed this out in June 14th of last year, and he claims that he met the provisions of the urgency ordinance by simply mailing it out. However, there's no evidence of the water board actually receiving this, or there's no evidence of him actually mailing it out, for that matter. And this determination that the Planning Commission arrived at was that it was his due diligence to somehow procure a receipt or any other form of evidence, his checking account, that the money had been cashed, and he wasn't able to do any of that. Therefore, the Planning Commission upheld the Planning Director's denial for that reason. And that's all there is to it. Do you have any questions?
Thank you. Any questions of staff by the board?
Yes, I have two questions. So from our side, how did we find out the NOI was not filed on time?
The water board gave us a list of NOIs that they had received. He was not on the list. We contacted the water board to clarify, perhaps his name was not on that list for whatever reason. The water board clarified that they never received an NOI or payment for it.
So was there anything on file with the water board with the applicant's name or the appellant's name?
Not with the water board, no.
Thank you.
Yep.
Thank you very much, Miguel. They said they mailed it in on June 14th,
Correct, June 14,
and the
2016.
deadline to be able to show that was September 7th?
September 7th, correct.
Okay, so there's almost 3 months.
Correct. He had 3 months to get some sort of documentation that showed that the water board received payment and the NOI.
And how much is the payment? Miguel?
$2,500.
So 3 months to recognize if a $2,500 check had cleared or not.
Correct. Many other registrants, the way they went about it is they contacted the water board and asked for an email confirming that they were in receipt. Other applicants asked for receipts. Other applicants brought in a cash check received from their bank or a bank statement. However, the appellant did none of that. So he could have easily avoided this if, come July and he noticed that $2,500 was still in his bank account. If he would have contacted the water board, perhaps this would have been resolved prior to the September 7th deadline.
Thank you.
I have a question. What was the date of inquiry of the water board by the planning department?
That was, actually, let me get that out.
And is that documented, is that a documented response?
I believe so.
Okay.
But either way, we do have a list from the water board themselves that his name is not on.
And what was the date of that list?
That was, it gets updated, or it used to get updated constantly. So there was some from October, November, December of last year.
Okay.
Actually, it doesn't seem like we have an email.
Okay.
We don't have it in this file.
All right. Well, that was made by email?
Yes, that was done by either email or phone call. If it was done by phone call, we do have a log at the planning department's
And
drive.
planning department can produce that, or code compliance can
Yes.
produce that log on request?
Yeah, we should be able to.
And also emails, if it was done by email, we can go through our IT department and get that if we need to?
Perhaps if it hasn't been deleted because of the 60-day.
Okay, I understand. Any further comments by staff?
What you note in the discussion, or it is noted in the discussion about a conversation with Trey Sherrill with the Central Valley Board here.
Yeah, and like I said, I just can't, it's been a while since I've looked at this, and I can't recall if it was a conversation through phone or through email. I wasn't the one that had that conversation.
Thank you, Supervisor Mills, my battery's dead. Okay, any further? We'll have a presentation by appellant or representative and/or both. Is the appellant here? Is any representative of the appellant here? Hearing and seeing none, we'll bring it back to the board for discussion.
One thing also I think we need to ask is, was the appellant able to provide you with a canceled check or any proof that he'd made a payment?
There's no proof whatsoever except those photographs that are date stamped June 14th.
Okay.
And the Planning Commission found that that was insufficient as proof.
Okay, at this time, we'll open up to public comment. You'll have a 5-minute period. Are there any speakers?
I just have one question. What's a NOI?
Notice of intent.
Oh,
You're welcome. I have trouble with those acronyms also. Any further public comments or public speakers?
Bill Wilson, District 1. I don't know, they didn't even show up. I guess they kind of figured the board's going to be set with planning's thing again. They said he had a canceled check or had a picture of a check, but never got it mailed to somebody. That's a pretty sloppy business practice, I'm sorry. But again, it's a piece of paper. When was the time, was he inspected? Was the rest of his packet clean? And he just missed the water board $2,500? Water board hasn't even been included in our inspections. The guy that we're talking about, Trey, now works for a company in Calaveras County. Griffin's the guy up there in charge now. They didn't show up. I wouldn't vote for them. Sorry.
Thank you, sir. Any further public comment? Hearing and seeing none, we'll come back to any summation and rebuttal by the appellant. And once again, I see no evidence of the appellant attending or his representative. We'll come back to staff summation and rebuttal.
I
Miguel?
just wanted to clarify that now that I recall, it was a phone conversation that one of the office techs had with the water board, and there is documentation of that conversation if, for whatever reason, it needs
Okay,
to be produced.
once again, that can be produced upon request.
Yes.
Thank you, sir. Any rebuttal by members of the public? Hearing and seeing none? Any board questions? Seeing no questions from the board, no questions from staff, we'll close the hearing. This time, the board will have discussion deliberation. Is there any deliberation by the board? Any questions of the board? Any questions by the board? Supervisor Toffenelli.
Mr. Chair, at this time, I would move to uphold the Planning Commission's denial of this appeal.
Second?
We have a motion by Supervisor Toffenelli to uphold the appeal by the Planning Commission, second by Supervisor Garamendi. All in favor indicate by saying aye. Aye. Opposed indicate by saying no. Hearing none, motion carries 5-0 unanimous.
Was that to uphold the appeal or uphold the denial?
Upon your denial, I'm sorry. I'll make sure we get that right.
Thank you.
It's been a long day.
What he said, but I said denial.
Madam Clerk.
Item 40 is to conduct, it's from the Planning Department, to conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-827 for Joshua Moore at a site approximately 2 miles north of State Highway 4 at the Stanislaus and Calaveras County line. APN 050-036-003.
Okay, ladies and gentlemen, the same rules apply here. This will be an appeals hearing. And I'll open the hearing now. I'm sorry. I'll give you folks a chance to get ready. I'm sorry.
Just a moment to set up, just a few minutes.
Oh, thank you.
I'm here, James Hansen, for the case. I just ran to get something to eat real quick.
That's okay.
I didn't make it back. I've been here since 9 a.m. For James Hansen, I'm listening on the live cut broadcast, and I heard the whole case. I wasn't able to make it back soon enough. If you guys could revisit the case, I'd like to present my side if possible.
I don't believe we can do that, sir. We've already voted.
I've been here
Counsel?
since 9 a.m.
Any comments on that? I don't think we can.
We're not on break.
Ultimately, the item was called. Certainly, there are reconsideration provisions within the board rules and procedures. Under the circumstances, the board can, if any board member wishes to reconsider this item to allow him an opportunity to be heard, that would be certainly within your discretion to exercise your reconsideration under your rules and procedures.
Thank you.
My landowner was also here for 3 hours.
Sir, give me a moment, please. In lieu of this information, I would elicit comments by the board members.
I would entertain the thought to have him present his case.
Supervisor Garamendi?
Generally, no, but it's in Supervisor Stefano's district.
I've seen him in the, he has been here all day, so.
I would go along with Gary, but I'd like to kick it behind the gentleman's up right now because he has attorney and stuff and it's costing him on the clock.
Supervisor Mills?
I would agree with Supervisor Clapp. We'll hear the case after.
I would agree with that also.
I would agree with that also. Sir, we're going to hear your comments after this next case. So, did you get something to eat? You're not going to go anywhere.
I hadn't eaten all day, man. I was
That's okay. It's all right. All right. Well, we'll give you an opportunity to speak,
I
sir.
appreciate it. I appreciate it, Lord.
Madam Clerk, could you call the case one more time, make sure we're on the right one,
Absolutely.
even though it's the last one?
So item 40 is from the Planning Department to conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-827 for Joshua Moore at a site approximately 2 miles north of State Highway 4 at the Stanislaus and Calaveras County line. APN 050-036-003.
Thank you, Madam Clerk. Once again, ladies and gentlemen, the rules still apply for the appeals hearing. We'll stick to that same schedule. And as soon as we can get our IT department working,
No, that's the other one.
Slide your slide. Your door might not be open. Thank you. Ethan, is the door open on? Is the door open?
Yeah.
I appreciate everybody spending the time, folks. We're not going to make this an all-nighter, but we will be adjourning here at 7:30 if we go that long, and we'll continue tomorrow. As long as the machine works.
But while the projector's warming up, Paul will go ahead with the overview of it.
What we can.
Okay, we'll open the hearing.
Very good. I'm Paul Groen with the Planning Department, and this is appeal number 2016-827. Jason Molinelli of Archer Norris on behalf of Joshua Moore is appealing a denial of a commercial cannabis registration by the Planning Commission. Now, the reasons the project was denied by the Planning Commission were the registrant did not produce evidence that no later than May 10, 2016, cultivation, grading, or earth moving commensurate with the area proposed to be developed occurred on the site. And also the application for registration contained false or misleading information. Oh, there we go. We've got a picture. Cool. Now the location, we're located out on the west side of the county. This is Highway 4, right where it hits the Stanislaus County line. If you were to stand right there at that point at the county line and go 2 miles north, you would be on the site. And actually, between that stock pond and the drawdown here is the cultivation area. This is actually a full section. It's 640.35 acres, and it is actually section number 4 of Township 1 North, Range 11 East.
Paul, I'm going to interrupt you for a second
Yes,
here.
sir.
We did have a last-minute
Oh,
request
yes.
for
I'm
continuance. And it's probably appropriate that the board consider that request first before we get involved in the details of the appeal itself. So perhaps Mr. Moore, as representative, can present his request for continuance, and you can decide on that first. And then if you decide to continue with the hearing today, then we can move forward with that.
Okay.
Yeah.
Counsel, we'll have to adjourn the hearing and hear the continuance matter?
You can hear that all within the hearing.
Okay, thank you. With no objection, as chair, I would agree with Mr. Mauer and hear the issue of continuance.
Thank you, Chair. Jason Molinelli for Appellant Joshua Moore. Good evening, board, council, staff. Thank you for your time to be here. So I had contacted planning, requested a continuance for a few reasons. There's a few more reasons that have come to my attention that I'll address as well. The first was I had a horrifically challenging trial schedule, still ongoing. I left that in the hands of other counsel while I'm here, and I take this matter just as serious as any other matter that I have. Nonetheless, I requested that continuance. For that reason, although I'm here now, but I'd also move to continue this hearing. Also of my doing, I delivered a brief, the appeal brief, very late in the afternoon yesterday to Mr. Grow. I don't know if you all have had a time to review that. There's a lot to digest in there. I don't want to prejudice your ability to render a informed decision. I don't want to prejudice my client's ability by not allowing you all time to properly analyze that. So if additional time would be helpful to the board. Also, there is a request for a remand to the Planning Commission in the brief, which may take additional time to analyze and consider. And if it would be helpful for the board to take additional time in that respect, also move for the continuance on those grounds. And also, although we've worked hard to generate necessary evidence in support of our appeal, there's still more out there that we have been unable to obtain. We provided a few declarants whose declarations were unsigned at the time of filing. However, I did bring signed declarations with me now, but had their schedules permitted, we would have liked them to be here to testify in person. There's additional, we'd like to make a more detailed search for historical photographs, because that is the central issue here. We were not able to obtain any of that, but we'd like to continue that search and to also contact further potential declarants or witnesses. We do have, we did bring one live witness with us, very kind of him to be here today. And also, with all due respect, I gave you guys my brief so late. However, I have not seen this to date. Planning's brief and presentation, and I can sit here and analyze it, and I think it's easy enough for me to follow, but I would like some additional time to take a look at this as well. This is the first I've seen that, so that I could be better prepared to respond to Planning's brief as well. And so basically, those are the grounds of, that I request continuance of this hearing. Should you decide not to continue the hearing, we're here and ready to go, and we'll do the best that we can under the circumstances. Thank you.
Thank you. Questions by the board? Supervisor Mills.
Yes, Ms. Mullaney, is that, did I pronounce it correctly?
Molinelli. Yeah.
Molinelli,
Close enough?
thank
No
you.
problem. Yes, sir.
When were you retained as counsel for this case?
I would say 6 weeks, 4 to 6 weeks ago. 4 weeks ago, maybe. Is that about right? Yeah, about a month ago. At some point after the planning, within that time period of 15 days, I believe, after the hearing in front of the Planning Commission.
Thank you.
Because there was a day, we had a day to get the request for appeal in, so a month ago. Yep.
Further questions? Mr. Moore, I apologize in advance.
That's all right.
Morinelli?
Molinelli.
Molinelli.
Jason.
Mr.
I'm,
M.
I'm fine with Jason.
I
Yes,
apologize.
sir. No, sir. It's all right.
Could you go into more specific information on, you mentioned items that were yet to be discovered, yet we talked about items. Could you be more specific on that? We're going to be talking about items that were presented to the Planning Commission on the first appeal.
Will we be talking about items presented to the planning? Yes. And that raises a great point. I don't have the full application. I'd like to get that from planning because there are items in there that I would submit do constitute proof of commensurate cultivation, receipts, and that we'd also like to get prior aerial photographs in the possession of planning or through planning, not necessarily in their possession. There's a June 3rd aerial photograph, but we'd like to go back even farther and attempt to scrutinize aerial photos from 2015. In addition, Mr. Moore is going through old phones, many of that don't work, and just really doing what I think is a great job of looking for historical photographs that predate that May 10th deadline. We've had some issues with old iPhones that aren't coming back to life, and so we've combed through emails, shadow boxes, photo boxes, looking for photographs that would be sufficient to establish prior cultivation commensurate with the activities in the application. So those are some of the evidentiary items that we think are out there, but we haven't been able to obtain.
So it's my understanding that that evidence was not presented at the appeals hearing for the Planning Commission, correct?
No, you are correct. Double negative. Yeah. Well, may I back up? Some of it, I presume, may have been. I was not a party to that hearing. So I guess in that respect, it's a little bit speculative, but I presume that some of the items we're referencing, receipts and other documentation may have been, that were in the original application may have been part of the Planning Commission hearing, but Mr. Maurer may know more than I on that front.
So, just so I make sure that we understand each other.
Sir.
There was evidence presented at the appeals hearing, but in addition to that, you may have further evidence that you would have this board consider. Is that correct?
That is correct.
And you understand, and I'm not, please, this is not, I don't want to insult you, you're an attorney. You understand that we may have that discretion to consider that evidence or not consider that evidence. Is that correct?
That's my understanding.
Is there something that would justify the continuance that you're not prepared to bring forth today?
Well, to answer that question, I would say that there is further evidence that I don't have here today that I believe exists. Further receipts, paperwork, documentation, permits, all which predate the May 10th, 2016 deadline, which would be, which we would say proves prior cultivation. And the two declarants who did sign declarations, they were unable to be here today. I would love for them to be here because they're articulate, great gentlemen, and photographs that I believe do exist. Mr. Moore knows they exist. It's a matter of accessing them, which we've had great difficulty doing.
I need to ask your client some questions. Could you have them come to the microphone, please?
No problem. Mr. Moore?
How's it going?
Sir, how are you?
Pretty good. How about yourself?
Good, good, a little tired.
Yeah.
I need to ask you questions regarding your, were you at the appeals hearing with the planning commission?
Yeah, I was.
Were you represented by an attorney at that time?
No, I was not.
Did you represent yourself?
I represented myself.
Did you present your case?
Well, I tried to, but these guys tore me up pretty good.
Okay. Did you feel you had all the evidence you needed?
No. I didn't have any of my receipts. I have other people that know we were cultivating up there last year. I have my landlord here that knows we were cultivating up there last year. Prior years, even before that, we've been cultivating up there. I have no picture evidence. Nobody takes pictures of this stuff, or used to not. So I don't have any photo evidence on me.
Okay. Thank you, sir.
Okay.
Staff, did we have anybody present at that appeals hearing? Ian?
Yeah, we were all here. Yeah.
Okay, all right,
Board Chair,
yes.
I would just want to remind the board, under our rules and procedures, no issue which was not addressed during the hearing upon which the appeal is based, so in other words, the Planning Commission hearing, shall be part of the appeal hearing. All relevant and known facts must be presented to the Planning Department staff and the Planning Commission. So all relevant known facts had to have been presented during the Planning Commission hearing. Between the Planning Commission hearing and the board hearing is not a time for a fishing expedition, for lack of a better way of saying it. Our code does allow that in the event that new information is presented on appeal, so for instance, if new information was not known at the time of the appeal hearing and that information is presented to the board does have the discretion to remand it back to the Planning Commission. But our code is very clear that all relevant and known facts must be presented during the time of the Planning Commission hearing.
Right. And I think we're operating in the body of what was not known at that time. Certainly, Mr. Moore was not represented by counsel, and there's an inequity there. I think at this point I'm sorry. I think I was just saying that at this point, I think we're operating in the realm of what was not known at that time, and that we have new and discovered factual evidence that we're attempting to obtain. And when I was speaking quietly, I was just making note that at the time of the hearing, Mr. Moore was not represented by counsel, which represents somewhat of an inequity, and that goes into what was known and what was not known at that time. And so I agree with Madam Counsel, and so that we're speaking of new facts that we've been attempting to generate, and have done made a good effort of it, and we're close, but we have not yet obtained that evidence that we're searching for, that we know exists. We're pretty sure it does.
Counsel, thank you very much.
Thank you,
Let's get back to our issue right now, and that's the issue of the continuance. Supervisor Mills, your light's on. Would you like to comment?
Well, Mr. Molinelli, a question is are you in possession of all of the documents that were presented at the Planning Commission hearing? Do you have those in your possession?
I do.
Okay. And so if we were to take up those pieces of information that were presented in the Planning Commission and those pieces of information only, you feel that there is no adequate defense?
No, I do not feel like that. However,
Your light's on.
I'm sorry. Go ahead.
Well, I was going to comment on an issue about him not being represented at the planning commission. That was by his choice. It's totally his choice and how he approached and went about it. So I think that's totally irrelevant to bring up. That was nothing to do with this board or even the planning commission board.
I understand,
So,
Supervisor.
and the fact that you're telling me that, I don't think that's the intent of our ordinance, is giving you time to go try and dig up more new evidence. It's in the light of some new evidence comes to light, not going and spending time digging, trying to find more evidence. That's not the intent of this, in my opinion. So I'm not in favor of going forward with a delay. I think we need to hear the evidence that was presented, that you testified, that you said you do have the evidence that was brought before the planning commission at this time. I think we need to go forward with that.
If I may, I completely agree and understand. Ready to go right now. If I had $1 for every time I told a client, why didn't you come to me earlier, I wouldn't be here right now. And that goes for all of us. I mean, how many times it happens in life where you think you can plow the field on your own, but then you get into it and you realize you're over your head. And so that's why I make that, because it's something that I come across so often. And it's self-serving for a lawyer to tell somebody, why didn't you come see me first? So yeah, that was his choice. And with respect to a continuance, it's not just based on our difficulties gaining that new evidence, which we know exists, but I also raised the issue of a potential continuance for your benefit and for my client's benefit, so that everybody here is fully informed and has an opportunity to really analyze the facts and legal citations in this brief. And if we're ready to do that, I'm ready to do that. So that really was the basis. We're ready to go. Shouldn't take up any more time of this. I know we all have families to get home to.
So, as I understand this, you're ready to go, so you're withdrawing your request?
I'm not withdrawing my request. I'm saying if the board so chooses not to continue this, if the board feels they're ready to consider our appeal at this point in time, we're ready to deliver it.
Counsel, poll of the board on the continuance issue?
Certainly, that would be a poll of the board. I would want the record to reflect that we did receive the legal brief from Mr. Molinar.
It's okay. Jason.
Jason, I'm sorry.
Jason.
Our office did review it. We did provide it to the board last night. Our office I have briefed this board on that legal memo. With the board polling on the continuance, I would also ask that the board poll to direct staff to come back to change, because our office unfortunately does see legal briefs in all kinds of appeals, not just cannabis appeals, that come the day before the appeal hearing. And so I would just ask that the board, that I poll the board to direct staff to come back with either a modification to the board rules and procedures or to the county ordinance to specify a date certain when any legal briefs need to be filed with the board to prevent any delay, and allow my office sufficient time to review the brief the board on our position, as well as for the board to have sufficient time to review the opposing brief as well as my office's brief.
Thank you, Counsel. Supervisor Topanelli, you were like first.
What's sufficient time, 3 days?
72 hours.
72 hours, 3 days?
72 hours would certainly be sufficient.
These are two separate pollings.
You had your light on. Supervisor Garamendi?
I'm sorry, I was going to agree with you. No, hold my comment.
All right. So just so I'm clear, Supervisor Topanelli, your poll answer is?
For which one?
To which?
There's two briefs.
May I?
On the continuance issue? And do you want to make that a modified?
Sir Chair.
poll, or would you like two separate polls, Counsel?
There would be two separate polls,
Okay.
one as to the continuance, and then the second would be my requested poll to direct staff to modify language in the future regarding briefing.
Chair Olivera, I'm sorry to interrupt, but I failed to mention again that this is 18 pages. I've never seen this. It wasn't produced to me last night or today. It was produced to me right now. And in that respect, I feel that myself and my applicant are prejudiced here at this appeal. I'd like, and I don't want to walk away from here for an hour and come back in an hour, but I'd like time to, which would also be another basis of the request for continuance, I'd like time to analyze this so that I can effectively respond on behalf of my client.
Understood, sir.
Mr. Chair, just like to clarify that. This is not new information. This is the same information that was presented to the Planning Commission, just packaged up slightly differently. So it is the same information that was provided to the applicant 2.5 months ago, and there is no new information in there. I'd also like to point out that Mr. Molinelli has been in contract with the appellant for at least 2 months, because he filed the appeal on April 27th. So, 27th. So there's been at least 2 months that Mr. Molinelli has been able to prepare for this hearing. In fact, we agreed that this hearing would be held this date back when we discussed extending the maximum 45-day appeal period or time frame to hear the appeal back in early May. So there's been plenty of opportunity. He knew this was a date that it was coming. There's no new information that we presented to him. The only thing that's new is just the packaging of the presentation of the information that was presented to the Planning Commission.
So as I understand it, the appeal was filed by counsel for the appellant.
By
2 months ago.
counsel on April 27th.
April 27th.
And I apologize because I did say that I know that he retained me 1 day before that 15-day period was over,
Okay.
which was after the appeal, and whether it was 4 months or 8 months, I mean, I misspoke, and my time flies. So
I understand, sir.
I might.
Supervisor.
Yes, when was it denied by the Planning Commission?
The commission
April
denied the
13th.
appeal, yeah.
April 13th?
Yes.
When was the appellant notified that they had been denied? At the Planning Commission?
They were,
February 28th was the denial date. It was appealed on March 15th, and the appeal hearing was April 13th.
Mr. Molinari, does your client currently have a crop in the ground?
not that I'm aware of. I don't believe so.
Sir?
I think we're speaking about
Have you
last-
planted for the season? No?
Okay, we're going to direct this back. Supervisor Tofinelli, do you have any further comments?
No.
Then let's deal with the first poll. That is the issue of continuance. Supervisor Tofinelli?
I'm not in favor of continuing.
Supervisor Garamendi?
Not in favor of continuance.
Supervisor Clapp?
Not in favor of continuing.
Supervisor Mills?
Prepared to hear it today.
Unanimous. All right, having said that,
Second poll.
we will be going back into the hearing process. We'll open the hearing back up. Oh, we're going to include it. Okay.
Second-
It's been a long
second
day.
poll.
It has been a long day.
Counsel? Okay.
The second poll would just be to direct staff on bringing back either a modification to the board rules or to the ordinance specifying a 72-hour advance filing for any legal briefs. And that would also include providing any PowerPoint presentation that staff would be making on any appeal hearing.
Just so I understand, would that be a poll or a vote of the board?
It would be a poll because I would be directing staff to bring something back at a future
Okay.
date.
Thank you. Board understand the issue by counsel? Supervisor Tofinelli?
Yes.
Supervisor Garamendi?
Yes.
Supervisor Clapp?
Yes.
Supervisor Mills?
Yes.
And I can agree, and I agree and concur, unanimous on the poll.
very good.
I think we can start our hearing
Very
again.
good. Thank you, and my apologies to the appellant for jumping ahead of that request for the continuance. I'll get back. let's just take it from the top here.
Time, let's just move on. We've already been through this.
Okay, that's fine, that's okay. So, there were two reasons for the denial. The first was based on County Code Section 1795-165 N3A and B. That requires the appellant to provide date stamp photographic evidence dated no later than May 10th of either grading, earth moving, cultivation on that site commensurate with the amount that was applied to be developed. Mr. Moore provided these 4 photographs that you see on the screen here. The first one up in the upper left is basically an index photograph for the other 3. The other 3 photographs show holes being drilled into the ground. And again, all of these photographs are dated April 11, 2015. It's basically a flat site from what you see right there. It appears to be a flat site, an open field. Holes are being drilled into the ground. You can see the auger mounted on the Bobcat. One thing I want you to note is there's no evidence of water or a drainage in this photograph. And the other thing in the photographs that you'll note is that the grass is pretty dry. It all appears to be pretty yellow at this point in time. Given that April 11, 2015 group of evidence photos, we went and started looking at aerial evidence. Again, this site is a whole section. We have a whole square mile to look over. Based upon what we found in later photographic evidence, our attention was drawn to this area right here. And this is a county aerial that's taken on June 3rd, 2016. Pretty typical of what we're going to see in all the photos. You're going to see the stock pond. You're going to see a drainage coming out of the stock pond, the draw. There's some trees in the drainage right here. Down in the lower left, you'll see there's a corral. And one thing I want you to note is, if you go to the upper left-hand corner of the corral, there's a fence line that takes off, crosses the draw, and over in this area in the future, we're going to be seeing a cultivation area. But as of June 3rd, 2016, there was no cultivation or earth moving in the draw. We didn't see evidence of that there, or on this hill across from the corral. Moving forward, we went to August 20th, 2016. And in this photograph, again, same topography, same site features. We see no cultivation or earth moving in the draw down along here. But across from the corral, following the fence line up on the hill, we see that there's some sort of cultivation in progress. The layout of that and the color of that, it's very suggestive of what we see in the evidence photographs that the appellant provided. So, having seen the aerial evidence, the aerial imagery, and comparing that to the evidence that the appellant had provided us, I took it upon myself to call Mr. Moore and have him explain why wasn't I seeing what I expected to see, especially back in the June 3rd photograph. I didn't see any evidence of cultivation. So I contacted Mr. Moore on February 17th, 2017. That was a discussion between him, the appellant, and myself from the planning department. What I asked him was, where are the holes shown in the photographs located? He explained to me that the holes had been made along the draw between the stock pond and that corral area. He also explained that cultivation of cannabis for personal use had occurred in the draw under the trees for years. I then asked him, why did he have photographs from 2015 to meet requirements that were not established until 2016? That seemed odd to me. The appellant explained that he did not have photographs showing cultivation when he became aware of the June 30th deadline and evidence requirements, meaning those evidence photographs. He explained the date of April 11, 2015 was added to his photographs as a historical reconstruction of cultivation in the draw in previous years. Based upon that discussion and examining the aerial evidence, And there not being any evidence of any other photos that were submitted other than the photographs of the holes to show that there was other cultivation or grading or earth moving going on at the site. The applicant was denied for failing to meet the requirements of providing that date stamped evidence showing grading, cultivation, and earth moving. Also, because the photos didn't accurately represent actual conditions on the ground, on the parcel, and because they purported to show evidence of activities, earth moving, that were required to occur on the parcel prior to May 10th, he was denied for providing false and misleading information. Subsequent to his denial, he did file a letter of an appeal to the Planning Commission. In that appeal, the appellant explained he did not understand why the denial letter stated the photographs were false and misleading. And he also asked why planning had accepted his application fee in the middle of July after having had the photos since the beginning of June. And actually, I believe we had those for about June 30th. And he was called back in on July 7th to submit his fee and complete the application. At the appeal hearing, Mr. Moore testified to these statements right here. He, at the appeal hearing, he said the 4 evidence photos were not false, but were in fact taken on April 11, 2015. The holes in the photos were dug in April so that he could do an outdoor cultivation. He excavated approximately 10,000 square feet when he excavated those holes. After he had done that, he then decided not to grow. He abandoned those holes, filled them in to prevent injury to his cattle. After doing that, he returned down to the draw where he did his traditional personal grow. Over the winter of 2015-2016, grass grew over the holes, which is why, Mr. Moore said, they were not visible in the county aerial of June 3rd, 2016. Also, as of May 10th, 2016, he testified he was not cultivating on the parcel. But after receiving his pending registration on July 7th, 2016, and being advised by his environmental consultant to move the cultivation 250 feet away from the draw, he established his 2016 cultivation area in what he's quoted as the exact same spot where the holes were drilled in 2015. Okay? So, what we saw in 2016, we should be able to go back and find those holes in 2015. So what we have here is an aerial that was taken July 3rd, 2015. This is 3 months after the holes were drilled on April 11th. And what we see is there's no holes in the draw, as he told me during our telephone conversation. And there are also no holes at the same spot, which is across from the corral and the draw and in this hill area right up here. So we didn't find what he claimed as far as the cultivation in the same spot. This makes it a little clearer, although I wish that screen was a little darker up there. Corral, fence line going across to the cultivation area of 2016. The same spot would be from the corral here going across the draw. We should be able to see something right there, but it's not there. Furthermore, the idea of that grass being yellow, that was also an issue at the Planning Commission hearing. The evidence photographs purport to be taken on April 11, 2015. The aerial you're looking at on the screen right there is a Google Earth image that's taken on March 29th, 2015. This is 13 days prior to the evidence photographs. And if we were to say that, as he first told me, those photographs were taken in the draw, there's actually a nice green strip coming right down that draw. Those holes were actually, excavated there from what he told me on the telephone. And if we go to what he said at the Planning Commission meeting, those holes were excavated on this hill over here, which shows quite a bit of green on it also. So, commission finding on the photographic evidence, and that was based on County Code Section 1795, 165, and 3A and B, and that requires that the registrant provide date-stamped photographic evidence of grading, earth moving, or cultivation no later than May 10th, 2016, which is commensurate with the area proposed to be cultivated. What the commission found was that there was no evidence of cultivation or grading shown in the photographs to begin with. The holes purportedly dug in 2015 were filled in, abandoned, and only the personal grow in the draw was cultivated. Even if the holes were dug, filled in, and abandoned, this was not evidence of earth moving. Also, the personal cultivation was not commensurate in size with the 22,000 square feet of cultivation area applied for. And therefore, the commission denied his appeal based on the photographic evidence requirement. On to false misleading reasoning here. There's a little further discussion. At the appeal hearing, the planning commissioners asked the appellant, did you verbally inform planning staff that the holes had been filled in before today, before the date of the hearing at the planning commission? That question was asked to Mr. Moore directly 3 times and indirectly one more time. And his responses were contradictory. The commission then asked staff, that being me, did the appellant tell you that the holes had been filled in before today? And my response then and today is that that day at the Planning Commission was the first day I heard the story about the holes being filled back in. So, the commission finding on the false and misleading reasoning comes under section 1795, 170A4 of the County Code. That states that registration of a medical cannabis cultivation site may be invalidated by the planning director if the application for registration contained false or misleading information. The commission found that because the appellant had not informed staff that the holes had been filled in, but had instead submitted those hole photos as evidence with his application, the appellant had in fact submitted false and misleading information. And those were the findings of the Planning Commission. Do you have any questions?
Okay. Any further presentation by staff? Sir, presentation by the appellant or representative.
Hello again, all. Jason Molinelli for appellant Joshua Moore. At the outset, there's plenty of information in there I've never seen or heard. I dispute the contention that that was all in the planning packet. If so, it's been amended and reconfigured, and there seems to be a good deal of information that was in that presentation that was not in the appeal packet that I received. Having said that, I'll get to the merits. Before I do that, actually, I have to raise an objection, and I do it with all due respect, that I perceive that there is a potential conflict of interest here through the dual representation of county council as counsel to the Board of Supervisors and counsel to the Planning Commission. And I say that as it's a potential conflict, and I reserve my right to further object if at any point in time in the future that potential conflict is proven or shown to be an actual conflict. And I say that with all due respect again because I have great respect and admiration for county council. However, there is a perceived potential conflict of interest here that can't be ignored. And again, if that is found to be an actual conflict, I would object to this hearing taking place under those grounds. There's evidence there that I had not prepared really to address, but I just want to raise one point. While I have it, it's in what I see as page 3. This photograph.
Let me go back. What's, excuse me,
Evidence photographs, County Aerial, June 3rd, 2016.
June 3rd?
Any one of those, really. Any one of those is fine.
There you
There,
go.
right there.
Yeah.
Just in response to the position of the commission or planning that there's no holes to be seen, it was brought to my attention that that little white, what looks like a cow, is not. It's a 16,000 gallon water tank, which to me means it's massive, and it looks tiny, such that it would appear that under no circumstance would any holes in the ground be visible through that aerial photograph that would refute Mr. Moore's testimony at the prior hearing. So I would state that is insufficient evidence to show whether or not there are holes in the ground. So moving forward, as we spoke of a little earlier, I provided you all with a brief yesterday afternoon. It was a lengthy brief. There's significant law and legal citations in that brief to digest and interpret. I take County Counsel's representation that she did so and conveyed that interpretation to you. But I do want to apologize for giving that to you so late. And I want to apologize to County Counsel for the late drop as well. I know it takes a lot of effort to get through that. But I can boil it down really into one very simple doctrine of law without citing all the cites. And before I paraphrase the law in that brief, I'll represent to you that all the law in there is properly interpreted and depicted and is not cited in any misleading fashion. And I want to say that before I paraphrase the law, because I don't want you to get the wrong intention. And County Counsel can certainly advise on the law as they see fit in the brief, subject to my prior objection. But to put it in a nutshell, because we can argue the law on another day in court, or if it may come to that. But for the purpose of this administrative hearing, it really relates to the doctrine of substantial compliance. If you ask, there's not many people left in here, but if you ask basically anybody what's their take on the laws, they would tell you that they're punitive and restrictive, and for the most part they are. But in California, in this great state, not all the laws are punitive and restrictive. In fact, some are encouraging and helpful, and that would be the law, the doctrine of substantial compliance, and that's cited in my brief. And in a nutshell, under California law, under that doctrine, substance prevails over form. When there's compliance as to all matters of substance in a statute, technical derivations are not to be given the stature of noncompliance. And that is why we're here today, because it's our position, as our brief sets forth, that Mr. Moore substantially complied with the urgency ordinance. And speaking to the urgency ordinance, we're in a bubble right here. And in that bubble, surrounding us is the urgency ordinance and California state statutory and case law and local law that's applicable to this issue. I leave politics outside the door because there's no place for that here. It may be that this is all for naught, that the future holds legislation where this is done, where there's no importance, a ban, for instance. But I ask that you set that aside today and operate inside the bubble, the universe where we're obligated and have a duty to contemplate this appeal hearing strictly under the terms of the urgency ordinance and applicable local and state law. Chairman Oliveira, I heard you say, I'm not going to say how many months ago because I'll get it wrong again, but it was quite a while back in a public hearing citing your prior law enforcement experience. You spoke on the sanctity and the integrity of following the law, and it was your duty to do so. And I'm not trying to gain favor, but that gave me goosebumps because that's the principles on which I operate too. And I just want to remind everyone and ask that we honor that sanctity and that integrity and determine this on the merits under the urgency ordinance. So again, substance prevails over form. Mr. Moore complied substantially and actually with the urgency ordinance. While he was unable to provide photos of prior cultivation under 1795-165N3, he provided other evidence of prior cultivation, which included receipts in his application, which are there, permits, other documentation. He provided oral testimony on the phone to planning and at the appeal hearing, proving that he was cultivating prior to May 10th, 2016. We've attached 2 declarations, one of which includes a statement, a sworn statement that that declarant, Tony Borba, was aware of the prior cultivation. We brought a witness, Mr. Dave Zuwalt, who also is the landowner of that 600 plus acres, who also can testify to the prior cultivation going on that parcel in commensurately that same area and commensurately in that same fashion. And I provide the definition of commensurate in the brief, which you can refer to. It's not an exact, precise, it doesn't have a precise meaning. Planning also had evidence in its possession, the permits, the receipts in the application, notes from the oral testimony, that they had knowledge and proved that he was cultivating prior to May 10th, 2016, commensurate with the activities under his application. And as I stated earlier, we had intended to continue our search for more evidence, which we believe is out there. Nonetheless, you have evidence in front of you that would substantially comply with the urgency ordinance that he was cultivating there under the Compassionate Use Act, the medical marijuana program. As such, Mr. Moore, he substantially complied with the requirements of the urgency ordinance, and his application should be granted. As my brief points out, which I hope you read these portions carefully, we cite precedents here in Calaveras County, many other examples of applications and appeal hearings. There's 3 to 5 sites in there of prior examples where other applicants have passed with similar substantial compliance, and they're there for your reading. And some of those examples are with respect to the exact same section of the urgency ordinance. Substantial compliance doesn't apply if the intent of the statute is frustrated. The urgency ordinance has a stated intent. It's in the statute itself, which include protect the public health, safety, and welfare of the residents of the county of Calaveras, eliminate the potential for significant additional impacts on the environment and unmitigated growth pending the adoption of an environmental impact report, and reduce conditions that create public nuisances. There is no better candidate, no better applicant that satisfies the spirit of the urgency ordinance than Mr. Moore. The cultivation is located basically smack dab in the middle of 600 acres, surrounded by, or on a 5-piece parcel of 1,600 acres. There's no negative impacts. There's no neighbors. It's not in a residential area. There's no neighbors who can smell the odor. The only thing smelling the odor out there is the cattle. And there's no traffic in and out of residential neighborhoods. There's no impact in that respect. His environmentalist, who we had hoped to have here, who was not, she would testify, and Josh would be happy to represent and testify as well, that when she saw the cultivation area last year, she thought it was beautiful, the best she's ever seen. No runoff. They have a stock pond. What's more, not only are there no negative impacts to the community or the environment, there are positive impacts that this applicant brings to the community and the environment. Created the stock pond, and you could read the declarations from his neighbors. And when I say neighbors, it's not like my neighbor I could look out the window and see him next door. It's the other gentlemen who have the other land around them, the agricultural preserve. They'll tell you how much they rely on Mr. Moore and have come to really appreciate his and value his place in that reserve there. He's helped with roads, with water, with cattle. He's genuinely friendly and helpful and supportive of his neighbors. In fact, the declarations you have, those declarants, they're not cannabis people per se, as you know, for lack of a better term, and yet they sign their name to those documents saying, hey, this is a fellow that we rely on, and if there is a candidate that we would support for cultivation in this county, it would be him. So in that respect, the impacts are beneficial. And again, it may be all for naught that cannabis cultivation is banned at some point in the county, but right now it's regulated under the urgency ordinance. Mr. Moore has substantially complied with the urgency ordinance. He's a stand-up guy, he's a family man, he's hardworking, he takes care of his neighbors, he's got a cultivation that only positively impacts the community environment, and for those reasons we would ask that you grant our appeal and reinstate his application with the planning to for further grant or whatever processes they may endeavor. That's all I have. I'm certainly open to questions. Again, I have the landowner here, quite a gentleman who'd be happy to speak to the prior cultivation, his knowledge of that, and to the value that he places on having Mr. Moore on his land. Thank you very much for your time. Appreciate that.
Thank you, Counsel.
Sir.
Did the landowner testify at the planning commission?
No, sir.
Counsel?
Oh, wait a minute. I don't know. I'm sorry. I shouldn't say.
Peter, did
Okay.
the landowner?
Ladies and gentlemen, one at a time, please. Supervisor Toffenelli, your question?
Yes, did the landowner speak at the planning commission?
I don't recall, I don't think so. I don't remember the landowner speaking.
Sir, could you stand up? Is that the landowner?
Come on up, sir.
Is that the landowner?
Yes, sir. Mr. Zamal.
Okay. Any staff member recall him being there?
I remember him being present in the audience, but I don't remember I don't think he spoke.
Okay. That answer your question?
I stated something about between the pictures, they said they could see no
Okay.
cultivation, that there was 225 cows and calves through there, that you couldn't see sign.
Sir, you'll have an opportunity. We need to hear from county council first. We're going to address issues as they were brought up by appellate's counsel. Go ahead.
A couple of issues that Mr. Molinelli brought up was the potential conflict with my office. And I would just like to advise the board there is substantial case law, specifically Whithome Ranch v. County of Sonoma, that actually identifies the role of county council, and a single county council or deputy county council can advise the planning department, the planning commission, and the board, as long as that advice is advisory and not prosecutorial. We have taken substantial strides to make sure that we do not cross over from advisory to prosecutorial, to the extent that Ethan Turner has advised the planning department and has represented the planning department in any of the appeal hearings. He does not speak to me or the planning department, the planning commission council as it relates to these hearings. So we do take a significant amount of strides to ensure that there are walls, that my representation of this board is advisory, that my office is advisory, and to the extent that Mr. Turner does cross over to prosecutorial, there are walls within my office that we do not cross. Specifically, I have not talked to Mr. Turner about this appeal, and I would like the record clear that I have not talked to Mr. Turner about this appeal.
Thank you, Council.
The other thing that I would like the record to be clear about is substantial compliance. And as the board knows, the board determines how strict they interpret their own laws, and whether they want to interpret things strictly or broadly, and what evidence they consider sufficient to meet the requirements of our own county code. You just have to be consistent when making or rendering your decisions. And finally, I have this on my notes, so I want the board to remind me when we get to this point. If there is going to be an adoption of any resolution, whether it's approving, granting, or denying the appeal, I would just ask that a finding be added to that resolution regarding the denial of the continuance. I have drafted some recommended language for a finding based on what was asked and what was said in this hearing. So when we get to that point, just remind me, and I can read it into the record, what I would recommend a finding be added for that resolution.
Thank you, Council. Any further, Supervisor Clapp, do you have a desire to speak? I'm sorry, sir. Okay. No. Supervisor Mills?
Is this time for questions?
We do have, I want to wait down to where the board has inquiry and discussion. At this time, we'll have presentation by members of the public. They'll be limited to 5 minutes per person. And sir, now's the opportunity that you can address the board. Yes, sir.
My name is David Swall. I own the property that the cultivation's on.
I'm going to ask you to speak right into that microphone, sir. So.
My name is David Swall. I own the property where the grow is, or my trust does, I guess now. But like I say, that one tank is 16,000 gallons water tank, been there for 21 years. Where they said the grass was dry, it was a drought that year, and I had them disc it before they drilled the holes so they wouldn't start a fire, and I didn't want any fire things. And my little brother had been growing pot down there since 1977 on the same water system.
Thank you, sir. Any further public comment?
And Josh been growing down there off the spring. So
I didn't.
Josh Moore grew the last 2 years down on that low ground along the spring too, using the same water as my brother used to.
Okay. Thank you, sir. Further comments by the public? Seeing none, I'll bring it back to summation and rebuttal by the appellant. 15 minutes, sir, for each appellant. Do you have any further information?
I would waive rebuttal.
Okay. Staff, summation and rebuttal?
Yes, there are, excuse me, Peter Maurer, Planning Director. There are a couple points I'd like to make in response to the presentation by Mr. Molinelli. First, he stated that you couldn't see the holes, but you can clearly see the holes that were dug. Granted, there are plants in there as well, but if there were holes in the ground, you could see those. We've seen hundreds of these photographs, aerial imaging, and you can see where the holes are. So I would dispute the fact that because you can't see them, they're too small. That's just not the case. We could see them. Secondly, when it comes to the substance over form and substantial compliance with the ordinance, the intent of this ordinance was to freeze cultivation as it was on May 10th last year. It didn't mean that someone who was growing a small personal plot could suddenly grow 22,000 square feet or any other amount. Unless it was to relocate it away from the 75-foot setback, that was the only provision in which you could move your cannabis cultivation area. This clearly, if he'd been growing, and there may have been a few plants down under the trees in the past. I don't think we're disputing that. But clearly, this is a significant expansion of whatever might have been growing previously. And it occurred after May 10th. And that was not only a strict prohibition of the code, it was the intent of the code to stop grading, to stop new cultivation until we had an ordinance in place. If this gentleman was such an upstanding citizen that he wanted to comply, he should have waited until a new ordinance was in place. He could have continued his personal grow as was allowed under the code. But the whole intent of the ordinance, the substance of the ordinance, was to freeze cultivation as it was on May 10th. And the whole purpose of the process that we went through and are continue to go through is to document that they were indeed growing in the area that they're now cultivating in. And so I would disagree that he met the substance of the code and the intent of the law. Clearly, this was in excess of that. I think that's all that I have to say, but I know that Mr. Turner has some points that he would like to make.
I don't know if Mr. Molinelli is aware, but the Planning Commission videos are available online on YouTube and on the Planning Coalition website. And had he watched them before this hearing, he would have known that several of the statements he made contradicted statements made by his client during that hearing. At 1 hour and 38 minutes in, 1 hour and 46 minutes in, Mr. Maurer asked him a series of questions to clarify his position. He said, were you previously growing in the draw? Mr. Moore said yes. Had you grown in the prepared cultivation area? No, we hadn't. And these are questions before, as it relates to activity before May 10th. Mr. Maurer said, this is a new cultivation site. He said yes. And then Mr. Moore moved the grow to an entirely new area where it didn't exist before. And Commissioner Wooster followed up with a question saying, if those holes were drilled, where they purport to be, what would the entire cultivation area be? And Mr. Moore said 10,000 feet after explaining he drilled 99 holes that were 10 feet apart. And so that's substantially less than 22,000 square feet, which is the applied for area. Mr. Molinelli also, in his brief, cited several other applications. I reviewed the photos that were referenced in those, and they are not as he characterized in his brief. He cited 2016-114. Those photos were not demonstrably false. They showed the cultivation area, and upon inspection by code compliance, they were found to depict exactly what they purported to depict. And in he also alleged that the date stamps were not visible on those photos, or that there were no date stamps on those photos, and there were. I looked in the data scan file, the date stamps are right there. And the other two are just not applicable because they show what they purport to show. They're found to be totally accurate when compared with aerial imagery, and when code and compliance went and did their inspections, they were found to contain cultivation sites that were the same square footage as was requested on the application. And I also want to discuss what we call the nightlife issue, which is the name of a case wherein lawyers within a single office at a county council, or might have been a city, I can't remember in that particular case, talk to each other about a prosecutorial activity where one advised the planning commission, I believe it was, and the other advised the planning department, the prosecutorial body. And we strictly observe those restrictions. We never discuss these cases. We both received a brief yesterday, and neither of us discussed it with one another at all. And that's how it is with every single case that is heard before either the planning commission or the board of supervisors. And I would like Paul to flip back, if you could, Paul, to the image of April, where the grass is obviously green.
You want to go forward to the...
Yeah, before it. Yeah, this photo is 13 days before the holes were reportedly drilled. It's clear that the grass is green. And I grew up on a cattle ranch at 1,000 feet up from sea level, which is similar to this, and never in living memory has the grass been brown like that in April. Not even after a 6-year drought, it's been green as it was in 2015 in this image. And that concludes my rebuttals. Paul, do you have anything else?
Yes, I think the only thing I'd like to add to this is there has not been any substantial addressing of any of the evidence that was part of the denial, the original denial, or the appeal to the board. Mr. Molinelli has not discussed those evidence photographs, reputed them one way or another, and also the aerial evidence. The factual evidence has not been addressed here, and that I would like to see, if there's any entertainment by this board at all to overturn the Planning Commission's appeal.
Council, I'm going to let you respond to those inquiries.
Thank you. First, with respect to my prior objection, I was fully satisfied by Madam County Counsel's explanation. Didn't need that from counsel here, but thank you. He misinterprets, misleads his analysis of that, completely ignoring Mr. Zawalt's testimony that he did something to it, some agricultural term, dissed it. So that would explain that, and there's no reason why it would be any other way, but appreciate the comments about the cattle ranch. With respect to Mr. Maurer's comments about substantial compliance and the intent of the statute, the intent is stated right there in the ordinance. I appreciate that Mr. Maurer has some opinions and feelings about what the intent was, but I think on the face of the statute, it's clear what the intent was as it was stated. That's the best kind of intent in a statute. You don't have to look at the legislative history. You don't have to guess. It's stated in the statute itself. And with respect to his analysis related to substantial compliance, that's a legal doctrine subject to a legal analysis. And with all due respect, I don't think he satisfied that analysis. Those little, the marks that they showed on that last photograph that they again say those are holes in the August photograph. Those are not holes. Those are 200-gallon pots, which are massive and would show up there such that holes would not. And there's commensurate, what is that? Commensurate parcel. With respect to the substantial compliance, saying that there was no compliance, and Mr. Turner said that I made some mistakes, some misrepresentations that were contrary to some prior testimony from my client at the last hearing. In fact, I was not mistaken. The term commensurate is ordinarily defined by Merriam-Webster as corresponding in size, extent, amount, or degree. 1795-165N3 states that, quote, medical cannabis applicants, quote, must provide evidence satisfactory to the planning director that no later than May 10, 2016, he or she has taken demonstrable steps towards the development of a commercial medical cannabis cultivation site on the parcel, not in the exact same place, on the parcel, commensurate with the application. Commensurate does not mean precise. Commensurate means corresponding in size, extent, amount, or degree. So that wasn't conflicting to what my client said earlier. And when you read that together, you see that he is in substantial compliance with his prior grows, which may or may not have been in the same place. Sounds like they weren't, but a little confusing. And Mr. Grow, yes, sir. With all due respect, the factual evidence is the factual evidence. We have addressed that. We said that the evidence presented at the Planning Commission hearing was substantially compliant with the urgency ordinance, and that's the argument. So I think that's my time. And again, always a pleasure to be in front of you all. Thank you. And I appreciate all the work that you do nonetheless. So thank you very much.
Okay, this time we'll have public comment rebuttal, rebuttal by the members of the public. Is there any speaker?
Bill Wilson again, District 1. 600 acres, didn't you say you wanted 600 acre minimum lot size for possible regulation, Mr. Tofinelli? Definitely big enough size. I understand a lot of people were very leery before 2015. You didn't take pictures. I happen to have a picture of my grow, my wife's grow. It has a background of the Butte fire in it. Definite photographic evidence. Unfortunately, we weren't able to expand. We didn't have the money to. We would have loved to. This gentleman grew or didn't grow. Looks like he may have grown. I don't know. I need your glasses. I need mine. I need a better photograph. I need to do a physical inspection of something to say, yeah, looks like there was earth movement there. Was it before May 10th? God, I don't know. I hope so. Some of this looks like there was. Some of it looks like there wasn't. He says he's not even growing right now. He's kind of complied with everything. You know, you denied him, what, almost a year after he applied? Again, we can kick everybody out. You know, it's hard to keep some people in. Thank you.
Okay, sir. Thank you. Any other speakers on this issue? Seeing none, hearing none, we'll bring it back to the board for questions of the appellate, counsel, or staff. Supervisor Mills?
Yes, this would be for Mr. Molinelli. Yeah, you are aware that the planning department, planning commission videos are on Google, and you can get them and review them at your leisure.
Is that on that internets thing I've heard about?
Okay.
Yeah, no, I was not aware of that, but now I am. I do appreciate that.
They're on YouTube, sir.
Okay, super. I am aware, I do from time to time watch your meetings. I was not aware that planning or any other agency in Calaveras County was also on the internet.
So who added the dates to the photographs?
I think that was admitted by Mr. Moore. And in fact, he admitted it. It wasn't an intent to mislead. It was a historical recreation. And to draw a comparison, I did the same thing on an application for another fella and brought it into planning. He said, how did those, not one of these gentlemen, they said, how did those dates get there? I said, well, I put them there. with the computer. He said, well, that's not going to do it. So I was afforded an opportunity to then go back and to go to the client and say, we can't put this historical recreation on here. That's not meeting the standards of the planning. How are we going to do it? Planning gave me a tip. They said, take a screenshot with your phone. I didn't even know what that was, but they told me how to do it. And so that's what we did. Mr. Moore did not receive that benefit. But outside of that, I recall when I was a kid, you'd get the photographs developed and there'd be a date on the back. But now there's no dates on photographs. We don't use cameras. We use phones. Nothing's dated except for a screenshot. And so that was why I spoke of earlier. We're trying to revive some of his old phones to try to take a screenshot of an old photograph. So, long answer.
Thank you for your answer. I understand that even on old phones, the digital record is there of the date in most of the older systems. The holes that were being dug, I'm looking at an auger that would probably 3 feet deep? 16 inches deep. And stated that you put the dirt back because of the cattle. The question would be, how did you put it back? Okay. So when you're doing that, you're really not compacting to anything close to native soil. Well, when you put dirt back that's been dug up, especially with an auger, sir, I've done undergrounding for years, and you've got to be able to achieve a 92% compaction rate to prevent divots or evidence, even later in that same season from occurring. So when I look at the picture of August right there, I could see something, but I see something another piece that's more interesting. And for Mr. Zwalt, who understands what I'm talking about, is when you drive over ground like that, you leave tracks. You can't avoid them, and years later, they're still there. Now you back up to the June tape, and I don't see any tracks. I don't even see tracks between the angled road and the one going up to the corral, much less talk about tracks going further up.
Sorry, I don't mean to interrupt, but we cannot hear on the video one thing that the appellant is saying.
Oh,
he should stand at the microphone.
I'm sorry.
I'm sorry, we can't hear anything you've said.
So what I'm trying to figure out is that why we don't have any evidence of tracks or ground disturbance that would be showing on that picture. It doesn't fit in my world that something didn't happen there.
I mean, there's the road coming in right there. You can see it's highly traveled right in the middle of the screen.
I understand. I see where the water tank is, but I'm looking up beyond the water tank and I'm not seeing any evidence of vehicles that had driven in that area recent to that photograph. You follow what I'm thinking?
No, I follow what you're saying.
Okay.
Yep.
Correct. There's no tracks in there. Now, number two is that when you turn in your
We were growing in the ditch at that point.
Sir?
We were in the creek bottom at that point. I didn't have a permit June 3rd. I had nothing.
Okay, so even if you had done the auger work in the year previous,
Yeah.
I would see on that photograph, if I were to blow it up, I would see pocketing or evidence of pocketing because you never did truly compact it back close enough to native after doing the auger work.
There's 300 cows up there through the winter.
I understand.
You think you're going to see that divot the following year after it's rained
Multiple
all winter
divots
Yeah.
will eventually, yes, they do show up. I'm just trying to make some points here.
Okay.
In your application, this would be on packet page 548 of our agenda. It says something of an admission of need to put in a 6-foot tall fence with gates. I don't see any evidence of a fence being put up here. Even if you were to take and shine the sunlight at an angle like you do with the water tank, as you can see, there's a shadow on the water tank. So I don't see any fence around that at all. Am I not seeing something here? Maybe this is a question to staff too. Did you put up a fence?
Yes, 100%.
It just doesn't really show that there's a fence there.
There's a fence there.
So on page 548 of our application, of your application, The dates, the signatures that are there, where the landowner and you signed off on it, what is the date that you signed off on it in the application?
If you could let us know, we don't have that in front of us.
Okay, because I'm seeing a date, both of you signed off, or somebody signed the same date, and I think it was the same person that signed it, at 7/7/16. July 7th, 16. In fact, at the bottom of the pages, and I go down 3 more pages, it says received July 7th, 2016. This is for the application to grow.
Oh, yeah, that's right. Okay. I was put on a waiting list because when I came in to turn my application, there were so many people in here. I turned it in not even expecting to get a permit. They said, we'll call you back when we can run through the list of people. And they called me back in like 2 weeks later after the June 30th deadline because there were so many people in here turning their applications in that they never could get to me that day. So they waited and called me like 3 weeks later.
Okay, so
And that's when I came back.
it does show a stamp of received on June 30th on the top of the application, but then there's
never
a
paid,
subsequent receipt of the full application then on July 7th, correct?
That's when I came back in and paid them.
Okay. That's all I have for now. Thank you.
Thank you, Supervisor Mills. Any further questions by the board? Seeing none, we'll close the hearing. We'll have a board discussion and deliberation. Any members would like to speak up, deliberate on this issue right now? Seeing, I'm sorry, County Council?
I would just like to add, because I was present in all of the hearings and everything when the urgency ordinance was adopted, I need to advise the board that the intent of the urgency ordinance was not to allow a grower to pick their grow up from one location and relocate it. The whole point and intent of the urgency ordinance was to stop the expansion and to stop new grows from starting in the county. New grows or expansion of grows or relocation of grows, the intention was that would be handled under a permanent ordinance. The urgency ordinance was to freeze things as they were on the day that it was adopted on May 10th. So the intention was not to allow a small grow to expand in a different area of that same parcel. It was to allow them to continue operating what they have historically operated in this, but for the setbacks, that would be the only option for relocating or moving their grow for the proportionate distance to accommodate the setback. But the urgency ordinance was intended to freeze cultivation to what it has historically been, not to expand or not to move or not to create new gardens.
My question would be to you then, that had he grown in the draw and that was in the wrong place and shown that he was growing in the draw and then moved it off of the draw to get away from it, that substantially would have been, as long as you maintain that size, everything's fine. Does that make sense?
Potentially, yes. The draw, I don't know why it would be moved from the draw. I don't know. But the only requirement for moving the location is setbacks.
Okay. Thank you.
Thank you. Thank you, Council. I'm afraid we're not. I'm sorry, what?
WQBC, you can't be within so many
Oh, sir, we can't hear that evidence. I'm sorry. I thought you mentioned something about the clock.
I would just note that the urgency ordinance does not address moving a grow in order to meet the requirements of the WQCB, the Water Quality Control Board. It does not address that. It only allows for moving a grow to accommodate setbacks.
Yeah, you rose a good point. I'm sorry. I thought you meant we're gonna continue until we hear the comments here. I hope the board understands, the staff understands. Otherwise, we'll be coming back tomorrow, and I think we can accomplish this today if that's okay with everybody. I'm going to address council. Does that present a problem for you? That's fine. And of course, Madam Clerk, I know that you're not happy about this, but I don't want you to come back tomorrow.
So
Oh, you
just
have to
so,
come back.
just so that we understand that we also have to hear the other appeal.
That's what I'm talking
Okay.
about. Yeah. Okay, having said that, any more deliberation by the board? I entertain a motion.
I would move to deny the appeal based upon the findings as the Planning Commission had found, and also to make a notation of the denial of the continuance, which I would ask County Council to insert into it due to our discussion.
Motion understood by all members? Second? Any second?
I'll second it.
Seconded by Supervisor Clapp. Any more public comment before we vote? Seeing and hearing none, we'll bring it back. All in favor of the motion by Supervisor Mills to uphold Planning Commission's denial and the modification dictated by council, indicate by saying aye.
Aye.
All opposed, indicate by saying no. Hearing none, motion passes 5-0, unanimous. Thank you. At this time, we're going to hear from the appellant. Madam Clerk, could you, for the record, at least read the agenda item?
I can. Item 39 is from the Planning Department to conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-717 for James Hansen on APN 046-017-098, file 2016-717.
Okay, sir, I'm going to ask you to take a position at the podium. And just so we understand, your matter has been heard and has been voted on by the board. The board may or may not take that into consideration, but the opportunity to speak in your behalf is afforded right now.
Okay, absolutely. Thank you for letting us hear this again. I was here all day. I was hungry and I was watching it on the video camera, and I was driving back. I was listening, so I thank you for that.
Okay.
My name is JJ Hansen. I'm the owner and CEO of Dang City Collective. My application was denied due to the water board not receiving paperwork that I had put in the mail and mailed off, as that was one of the methods that was acceptable. Either you could go online and pay online. You could walk the paperwork and the payment into the office physically, or you could mail it in the mail, which I did. It didn't say it had to be registered mail, or else I would have done that. And I snapped photographs of the day that I did it. I believe it was June 14th of last year. And I snapped photographics of the letter that I put inside the mail and the contents that was in the letter, which was the filled out documentation to the water board, and then the $2,500 check. After I did that, honestly, I thought it was taken care of. I didn't know I had to follow back up with them to see if they had received it. It didn't say in any paperwork that, how they would respond to say that they received it. In all due honesty, I was up at the farm, and I heard in the video when I was driving back here that they said if I didn't check my account to see if a $2,500 was deducted out. We don't have internet access up there, and to be quite honest, we were in such a scramble from getting the permit. I probably didn't even check my account until after the season in October. I was just putting money barely in there to pay my bills and stuff. So I wouldn't have recollected the $2,500 getting taken out. I might note that I do have over 500 patients that have signed up on my membership. now at Dang City Collective since I've had since 2015. And to deny this paperwork over what I feel would be a technicality in the mail would be a tragedy to all the patients that depend on medicine from Dang City Collective that I was able to cultivate here in the county. So I'd ask you guys for a way to grant me this. I'm sorry, I lost my place. I do have here my landowner too. I'd like to have him step up and say a few things about character witness and whatnot, so you guys could take that into your decision as well.
I think right now the issue is whether or not you paid your $2,500 fee and how that got processed, so.
Right, so,
to be,
so the
not,
next.
not to be rude, but
Okay, yeah,
I
not a
think we're
problem.
dealing with that issue, sir.
Not a problem, not a problem. So, the first time of me hearing about anything about my application since I had got the application granted to me, I think at the end of June, I believe it was, or at the end of May, whenever I got my permit, was when they contacted me in March about the water board not receiving the paperwork and the check that I had sent off back in June. So I think that was the first time them reviewing my application was in March, 10 months after I got my permit. So that's the first time that I had heard that the water board had not received it. I didn't know I needed to follow up and check my account to see if that check. I still haven't voided that check. So
Have you contacted the water board about this?
I did contact as soon as they contacted me in March about the water board not receiving my document and check that I mailed off. I contacted a gentleman by the name of Terrell, and he, extensively researched the systems, and he could not find it. So obviously, it did get lost in the mail, and that's the evidence that I had showing that I did actually mail it off, and the date stamps on those evidence on the photographs. And I believe at the appeal hearing, they said, what about getting it registered? And, that wasn't a requirement in one of the methods. It just said by mail, or else I would have gotten it registered. So, yeah, that's why we're here today,
Okay. Thank you, sir.
Mm-hmm.
Questions of the board, County Council?
I just wanted to remind the board that the burden of proof is on the appellant. So the appellant has to produce sufficient evidence that they meet all of the requirements of the urgency ordinance. The burden is not on the county to follow up. It's on the applicant.
Okay. Thank you, Council. Comments by the board?
Did you receive a canceled check from the water board?
No, I did not.
So they still have it, or somebody still has it?
Well, I mean, since it's not in their possession, obviously it got lost in the mail. Since
Sure.
I'm
sorry.
No, that's fine.
Sir, do you balance your statement on your checking account?
Say that again?
Do you balance your statement on your checking accounts?
Balance them, like review them.
Actually check, make sure the bank doesn't make a mistake?
No,
monthly?
honestly, I do not. No.
Did you notice you had an extra $2,500 in your checking account?
You know what? I was spending so much money last year, and putting money in. Honestly, $2,500 could have easily gotten looked over.
Okay, I can understand that.
Yeah.
I'll bring it back. Supervisor Garamendi?
You seem like a decent fella, but I mean, we have this situation where we have no evidence to say where things are at. And we are stuck, we have to follow certain rules, apply them universally. I know how things get busy. I know, it's hard to keep track of all that stuff. I feel for it.
Even if one of the methods was to mail out, that was one of the methods that was okayed by you guys. I just hate to get denied by a simple technicality. I feel it's the mail's fault. You know, there's stuff, I'm sure we've all lost packages in the mail. You know, in hindsight, yes, I wish I would have just physically took it in there.
You
You
actually
know, or
trusted
done it
it.
online, but you know.
Counsel, you lit up. I'm sorry, Supervisor Tofinelli, but do you have something?
Just to remind the board, when my office has to serve another party with any kind of documentation and we need to provide verification or evidence that they were in fact served with whatever it was that we were serving, we do have to either do a proof of service or there has to be some sent certified mail. Certified mail provides a receipt that it was in fact sent and that it was in fact delivered. So certainly if it was sent certified mail, there would be that evidence to show that it was in the mail. I just wanted to remind the board that, again, the burden is on the applicant to provide evidence that it was in fact done.
Yeah, I was like to say something that I've been paying taxes for 50-some years now. And even when I was 18 years old, when I mailed my taxes in, I got proof of mail. It's 75 cents today. It used to be like a quarter. And it's a little piece of paper, and it just says that the post office mailed this piece of mail to this address from here at this time. And I've never been audited, or I've been audited, but I never had it lost. But when I mailed my taxes in this year, I still paid the extra fee because it is that important. And if I was getting a permit process, even I would do it even on that point. Even 50 years ago, I would have done it if it's that important. It's just, and it was very important because if you're here now.
Okay, at this time, I'd poll the board to let the previous vote stand or to reopen the case. Supervisor Tofinelli?
I let the previous vote stand.
Supervisor Garamendi? Indicating by nodding his head. Supervisor Platt? And indicating by nodding his head. Supervisor Mills?
I'm sorry, the vote's got to stand.
I'd be the unanimous vote on that. Thank you, sir. I'm sorry. Madam Clerk.
Supervisor announcements. In compliance with AB 1234, chaptered as Government Code Section 53232.3D, this is the time for board members to report on meetings attended on behalf of the county and to carry out their duties as a county supervisor.
I'll go first. I want to go home.
In deference to Diane, I'll forego my discussion so you can go home.
I could. Okay, all right. Yeah, I'll reserve reporting out till next meeting.
I apologize for this is all right. I didn't report out to you. We're going to get you. We're going to get you up in the hallway. At the RCRC, sorry. But that was on tape. But the RCRC meeting last week, just because it impacts what we're doing here. The RCRC board voted to endorse H.R. 975, which is a Roy Bacher amendment that is co-authored by our congressman. It's the Respect for State Marijuana Laws Act of 2017. It basically says that they are directing the Department of Justice to spend no funds enforcing federal law on cannabis in states that have legal places, and it names out specifically California. This is germane to what we're doing because there has been consideration that the feds were going to come in. I don't think Attorney General Sessions is going to come into a district that is where the author of this bill represents. So as we deal with our local congressional race, not race, but congressman, it's just important that we all are aware where he is regarding federal intervention in the state law. And the RCRC voted to endorse that, his Roy Bacher bill.
Thank you, Supervisor Garamendi. Supervisor Tofinelli.
I was going to report out, but Tim's not here. We did finally meet with P&J and Tetra Tech on their invoices and with that, but since I'll wait till next time, our next meeting when Tim will be here, because he attended that with me. But there was a question earlier today by one of the public speakers during public comment period, saying that we continue to make a big secret about how much we've collected from Measure C funds. And I asked for some documentation on that, and as of this morning at 9 o'clock, the county has received $4.796 million in Measure C funds. So that's up to date as of today.
With that, staff, any reporting out?
Mr. Chairman, you had asked that I provide an update on where we're at with the EIR. It's in process. Unless there's any specific questions you have of me, I don't have a whole lot to say, and I'll let you guys go.
Okay. Mr. Mauer, thank you very much for staying. Staff and folks, it's been a long day, but we got it done, and I want to thank you personally for your patience. Meeting adjourned.